Hello friends, welcome to ixam. We have started legal mock test series in which we are discussing questions from important sections of various acts. And today in this video we are going to discuss important questions from Code of Criminal Procedure. The topic is Chapter 6, Process to Compel Appearance. This deals with section number 61 to section number 90 of the Criminal Procedure Code. So starting with the first question, how are summons served? By a police officer, by an officer of court, by an authorized public servant, by any of the above? None. The correct answer is D, by any of the above. This is present under section number 62 of Criminal Procedure Code. How summons are served? Every summons shall be served by a police officer or subject to such rules as the state government may make in this behalf, by an officer of court issuing it, or other public servant. So all the three are mentioned in subsection 1. Subsection 2 says, if practicable, the summons shall be served personally to the person summoned by delivering or tendering to him one of the duplicates of the summons, and the person should also sign a receipt thereof on the back of the other duplicate. Question number 2, under which section of Criminal Procedure Code the summons may be served by leaving it with some adult member of the family? This is given under section number 64 of the Criminal Procedure Code. Section 64 deals with the service when person summoned cannot be found. Where the person summoned cannot, by exercise of due diligence, be found, the summons may be served by leaving one of the duplicates for him with some adult male member of his family residing with him. In the explanation, it is also given, a servant is not a member of the family within the meaning of this section. Question number 3. How long a warrant of arrest shall remain in force? 6 years, 10 years, 12 years, until executed or cancelled, 2 years. The correct answer is D, until executed or cancelled. A warrant of arrest will remain in force until it is executed or cancelled. This is given under section number 70 of the Criminal Procedure Code. Question number 4. A warrant issued in terms of Criminal Procedure Code may be executed at any place in India, in home district of accused residence, within jurisdiction of issuing court, concerned state, or the place determined by the court. The correct answer is A. Warrant issued in terms of Criminal Procedure Code may be executed at any place in India. This is given under section number 77 of the Criminal Procedure Code. Question number 5. Period of appearance for proclamation issued under section number 82 of Criminal Procedure Code is not less than. The correct answer is 30 days. तो इसका मतलब कि अगर किसी के लिए proclamation issue किया है for appearance in the court, so within a period of 30 days from the date of issue of proclamation, the person is to appear in front of the court. This is given under section number 82 of Criminal Procedure Code. Proclamation for person absconding, the person is evading arrest, he has absconded or concealing himself so that such warrant cannot be executed. A written proclamation then can be published requiring him to appear at a specified place and at a specified time, not less than 30 days from the date of publishing of such proclamation. Question number 6. An absconder's property is sold after how many months after attachment of his property? Now, if there is a person who is absconding arrest, who is concealing himself so that the warrant of arrest cannot be executed, तो उसके अगेंस्ट proclamation issue हो सकती है. उस proclamation के 30 days के अंदर the person is expected to appear. अब proclamation issue करने के बाद भी वो person कोर्ट में नहीं आता है, he doesn't appear in the court, और कोर्ट को ऐसा लगता है that the person is about to dispose of a part of property or whole of property or is trying to remove the property from the jurisdiction of the court. In that case, the court may order the attachment of his property. इस attachment के बाद 6 months तक the property cannot be sold off. अगर कोई person है जिसको उस property में interest है, who is not the absconder, जिसका कोई interest है, claims है या objections है with respect to attachment of the property, तो attachment के 6 महीने के अंदर they can raise their claims and objections. Once those 6 months have expired, then that property can be sold off. और अगर मान लो अटैचमेंट के 6 महीने के बाद वो प्रॉपर्टी सेल कर दी गई है, तो उस अटैचमेंट के 2 साल के अंदर तक जो एब्सकॉन्डर है, he can come back, he can give sufficient reasons to the court, the reasons due to which he was not able to appear in the court, and he can either claim his property अगर प्रॉपर्टी सेल नहीं हुई है, or can claim the proceeds of the property. तो इस क्वेश्चन में प्रॉपर्टी अटैच होने के कितने मंथ्स के बाद सेल ऑफ की जा सकती है, ये आपका सेक्शन नंबर 85 ऑफ CrPC में दिया हुआ है. द प्रॉपर्टी कैन बी डिस्पोज्ड ऑफ बाय द गवर्नमेंट आफ्टर द एक्सपायरी ऑफ 6 months. Then the next question is, a proclaimed person whose property has been attached can claim the property or the sale proceeds on appearance within. The correct answer, as I've already told you, is 2 years of attachment. तो प्रॉपर्टी अटैच होने के 2 साल के अंदर अंदर अगर मान लो वो 6 महीने के बाद बिक भी गई है तो उसके प्रोसीड्स लेने भी आ सकता है या फिर अपनी प्रॉपर्टी भी वापस लेने आ सकता है अगर वो सेल नहीं हुई होगी. दिस इज गिवन अंडर सेक्शन नंबर 85 ऑफ CrPC सबसेक्शन 3. Moving to next question, question 8. As per section 87 of CrPC, in which of the following circumstances a warrant of arrest can be issued by the court? So warrant of arrest in lieu of summons का section है section number 87. Options are summoned person has absconded, summoned person will disobey the summons, summoned person failed to appear without any reasonable cause, both A and C, all A, B and C. The correct answer here is E. ये आपके सेक्शन नंबर 87 क्रिमिनल प्रोसीजर कोड में क्लियरली दिया हुआ है. अगर कोर्ट को ऐसा लगता है कभी भी that the person has either absconded or will not obey the summons or he fails to appear and the summons is proved to be duly served, there was no reasonable excuse, in that case warrant of arrest can be issued. Question number 9. Which of the following is true? A warrant of arrest cannot be endorsed to another officer. The person to be arrested need not be shown the warrant but should be told about the substance of arrest. Option C. Person to be arrested should be brought before the court within 24 hours inclusive of journey time. Option D. All are true. Option E. None is true. The correct answer is E. तीनों में से कोई भी स्टेटमेंट्स करेक्ट नहीं है. अगर आप इनके एक्सप्लेनेशन को देखें, सेक्शन 74 क्लियरली टॉक्स अबाउट द एग्जीक्यूशन ऑफ अ वारंट ऑफ अरेस्ट व्हेन इट इज डायरेक्टेड और एंडोर्स्ड टू अनदर ऑफिसर. तो इसका मतलब इसको एंडोर्स किया जा सकता है. सेक्शन 75 टॉक्स अबाउट नोटिफिकेशन ऑफ सब्सटेंस ऑफ वारंट. तो सब्सटेंस ऑफ अरेस्ट बताने के साथ साथ वारंट भी दिखाना जरूरी है. Section 76 deals with person arrested to be brought before court without delay. तो 24 hours में person को कोर्ट के सामने लाना चाहिए, exclusive of the journey time, not inclusive. So that is why option C is also wrong. The correct answer is all are incorrect in the question. Moving to last question, which of the following need not be mentioned in the endorsement of bond attached with the warrant of arrest? Option A, number of shot is required. Option B, amount of bond. C, time of appearance in court. D, substance of warrant of arrest. E, all should be mentioned. Correct answer here is D. Substance of warrant of arrest को endorsement में mention करने की जरूरत नहीं है, बाकी तीनों चीजें mention होनी चाहिए. This is given under section number 71 of the Criminal Procedure Code. Endorsement shall state all these things. So this was all from chapter number 6. In the next video, you will have revision of few other sections from different acts. I hope you are finding these useful. You can share your feedback or expectations or queries in the comment below. अगर आपके कोई भी doubts हैं, आप वो भी नीचे comment section में mention कर सकते हैं. Also, if you need any form of guidance or direction, you can reach out to us on this number. ixam helps you prepare 50% faster with a crisp and concise content and with all the efforts, with all the personalized guidance that we can offer you. Subscribe to our channel and stay tuned with information relating to law exams. Thank you.